I mean, it's got a long historical background of treating children as property, to some extent property of their parents. But I also think when you look at sort of what the state is saying in terms of decision making around healthcare, it seems like there's also property of the state in some ways as well. I mean, if you look at parents who have been given this proprietary right, they don't generally include Indigenous parents. So there is that colonial aspect as well. But so there's this long standing view of children as property. We used to use and we still use terms like custody when referring to children, but we're moving away from that. And to some extent, like the Divorce Act is no longer using custody; they're using parenting time, and sort of trying to flip things to look at it as more from the point of view of children. Unfortunately, in our education systems, and most education legislation is pretty archaic. I mean, most pupils, students, we still, in many pieces of legislation, still call them pupils. And these are sort of archaic terms we don't use generally. Granting parents all kinds of rights to make decisions about the students themselves, even well into the teen years. So we do have that long history of parental rights. However, we are moving toward recognizing that parents need to act in their own children's best interests. They need to act in a way to protect their safety and their right to health. So that, but once again, we've got the state is the one that steps in when that doesn't happen. So there are some issues around that. I mean, the Article 5 of the UN Convention on the Rights of the Child talks about supporting parents in their primary role with their children. However, it says so in accordance with the evolving capacities of children. We also have Article 12 that says that any decisions that are made that have a significant impact on children have to give consideration to their voice and their views and wishes, also in accordance with their capacities. So there is some acknowledgement that children, their points of view evolve and change, and they become better able to make decisions as they get older, but there's a requirement that they be consulted. And even there are some general comments that have come out of the UN Committee on the Rights of the Child that help people interpret how the convention is to be interpreted, and there are some general comments about how do you elicit the views and preferences and wishes of very young children, so we don't have to keep it as this sort of model of autonomy and mature autonomous decision making. There's lots of ways that we can take into consideration the points of view of children, but Canada, I mean, the UN Convention on the Rights of the Child has been ratified by Canada. It's also been ratified by every province, which a lot of provinces like to say, well, we don't care about the UN Convention because that's some federal treaty that's been entered into. But in fact, every single province in this country actually passed a resolution affirming the UN Convention on the Rights of the Child. So I think Alberta was the last one to do it, but they did do it. And it's you know, the Supreme Court of Canada, in a case called Numbered Company Quebec Inc., really sort of did a hierarchy of what are the international law that is important, and at the top are treaties that have been fully ratified, and the UNCRC has been incorporated by reference into pieces of legislation across the country and has been used by the Supreme Court of Canada repeatedly as an interpretive tool to children's constitutional rights. So, you know, clearly you have Section 15 rights, and while we don't have the Supreme Court of Canada specifically recognizing gender orientation as an analogous ground, I don't think that it's a huge leap for them to do so. I would expect that if a case went up on that basis, they would recognize it. But that, so, and I do also think that there are some Section 7 rights in terms of security of the person that young people could assert in these cases. Unfortunately, if provincial governments are inclined to use the notwithstanding clause in order to pander to a particular base of voters, the charter doesn't help very much. Although they may be the kind of extreme cases that if it gets to the Supreme Court of Canada, we may see the Supreme Court have to take a serious look at, what are their boundaries or guardrails around Section 33 and the use of the notwithstanding clause. In particular, given that one of the fundamental values of our charter is the protection of minorities. The court recognized that in the succession reference, and now, yes, it was in the context of the French minority in Canada, but they did say minorities, and I think that the tyranny of the majority against the marginalized groups is something that it would be very interesting to hear what a higher court might say about the use of the notwithstanding clause to oppress an extremely vulnerable group. Notwithstanding clause presupposes that there can be democratic override against governments who have invoked it wrongfully. And for those who, and there's a growing number of people who are unhappy about the use of that to oppress minorities, and we need to see it in the ballot box.